Hi, this is Jim Cunningham. We're going to talk about small business lawyer. Do you really need one? Right? So, a lot of people who are in business, they're thinking about a business. They might be thinking about setting up an LLC in California or a partnership or a corporation. Do you really need a lawyer for this? So, what we're going to do is we're going to unpack when you need a lawyer. Sometimes you don't. It kind of depends on the situation. But what we'll do is we'll walk through, frankly, why people hire lawyers in the first place. So, does a small business really need a lawyer, or what about Chat GPT? Can't you just use AI? And I will tell you, spoiler alert, lawyers, including lawyers in our firm, we use a lot of technology tools, including AI. We used closed AI, meaning we're not putting sensitive client information into a large language model. It's gated, and that is kind of the current ethics rules in California. But as lawyers, we're using it, and we'll talk about why that's the case, and why there are lawyers who use AI and lawyers who don't. But the lawyers who aren't using it, they're going to be at a competitive disadvantage here in about 2 seconds. Lawyers help clients navigate issues, complex issues and regulations, and lawyers, really a business lawyer should deliver value. So if you're a business owner and you pay a lawyer $1,000, they should be delivering you more than $1,000 in value, right? That's kind of the idea, is delivering value. So there are different stages of when you might need a business lawyer. One is formation. So setting that up, we're going to talk about that, the choices you can make, operating the business, the ongoing day-to-day. Taxes do come up. If you have a business, you're going to be taxed. Even if you have a nonprofit, there's a level of tax effectively that you're paying. But what we're talking here primarily is our for-profit businesses, and there are taxes that have to be paid. There are fees that have to be paid to the state, because all of these entities that we're talking about, with the exception of a sole proprietorship and a general partnership, have to be registered with the state. So you're going to have to pay some type of fee. And then we'll talk briefly about sale and winding up. So what happens at the end when you're ready to stop the business. So if you're watching this on YouTube, please go ahead and subscribe to our YouTube channel. Give us a thumbs up. That helps. And if you click the bell, you'll be alerted when we drop content, which is typically Thursdays at 6 p.m. Pacific time. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've been an attorney for 30 years. I am a certified specialist in estate planning, trust, and probate law. And I'm a pilot. I'm a securities and insurance license, as well as a real estate broker. I'm a pilot, single engine land, instrument rated. I'm not current, but sort of a broad background, and that really helps. Also a business owner. So, right, I'm also a shareholder at Cunningham Legal. So I'm living and breathing this on a daily basis. These are the 18 lawyers now that we have at our firm, Cunningham Legal. We are devoted to all things peaceful succession, or peaceful transfer of wealth from one generation to the next. And this does include business owners. So typically it's going to be a family-owned business and that we're working on, or maybe two families that own a business. But typically this is within the context of estate planning, which, if you have assets, you're going to need estate planning. And this is very important, a disclaimer. I'm a lawyer. We're going to be covering a lot of stuff very fast. This is not legal advice. This is really important. So we're here to provide information. We're here to educate, hopefully entertain just a little bit, because this stuff can be, drier than the Sahara Desert in July, but we're going to humorous spin sometimes when appropriate. But really important, this is important, is really this. A lot of what we're talking about should be done with a lawyer. And when I say there's no attorney-client relationship that's forming here. So what about do it yourself or AI to set up, run, or close a business? I'm going to start with this, because really this is like whether you need a lawyer or not. But let's start with, what if you don't? I mean, do you really need a lawyer for this stuff? Can you do this without a lawyer? Well, the short answer is yes. Okay, technically. I would say the better answer is the do-it-yourself legal work is a bit like building your own parachute, and you're going to jump out of the plane. You better know what you're doing, or you're going to end up with a high-speed splat. Okay, that's the pilot's version of ruining your whole day, right? So if that parachute doesn't deploy as intended, it's going to ruin your day. You're going to have problems. And what we're going to do is we're going to get specific on this. So let's talk about formation. So this is somebody who says, I have a great idea. I want to set up a business, a lemonade stand, whatever it is. You want to start up a business. You can be a sole proprietor, which I say, it's a guy in a truck and a lawnmower, and you're going around mowing people's lawns, and they pay you $50. Well, that's a sole proprietor. You don't have to register with the state. You don't have to do anything. Should you have insurance? Should you have all this other stuff? Yes, but it's a free country. It's still a free country. You can still put that lawnmower in the back of your truck and drive around and mow people's lawns and collect your 50 or $100 or whatever people are willing to pay you. If you set up nothing else, that is legally considered a sole proprietorship. If two people do it, right, it's considered a partnership, and you do not have to file at a state, whether it's California or another state, you do not have to file to form a general partnership. Anything else, LLC, S Corp, C Corp, you can register a general partnership. If you want to create a limited partnership, that is going to require some type of filing at the Secretary of State's office. So I'm doing this from Sacramento, from our Sacramento office today. Secretary of State's office is just a few blocks from our office. We're located on Capitol Mall. So you need to walk over there or go online and register and create this entity. So if more than one person is involved, but this is really just basic stuff. I mean, this goes back thousands of years. If more than one person is involved, it's important to define who owns what. Okay. So in the world, there are owners and there are loaners. So there are loaners, which is you lend somebody money, or there are owners, which is you invest in a venture. So let me give an example. Abel and Baker start a company. Abel puts in $10,000 and Baker puts in zero. So this is also known as sweat equity. Are they 50-50 partners, right? Or is Baker Abel's employee? When does Abel get his $10,000 back, right? If Abel's putting in 10,000 and Baker's putting in zero, somebody might say, well, Abel owns it because he put in the money. But Baker will say, well, wait a minute, Abel, you have 10,000. I don't. I'm putting in my efforts to build this company. Well, Abel in that instance might be a loaner. And actually, more technically, it's a capital contribution, meaning Abel puts money in there. So that may be Abel's capital. And so that when this thing is wound up or when it's dissolved, Abel should be able to get his capital back. Okay. There might be interest on that capital, but you can see right from the get-go, if two people are doing this, you might have some legal issues here. And really, that's when it makes sense to get some legal advice, right? So talk to a lawyer. It may not be a big engagement. It may be a single meeting with a lawyer, but it's something where you would want to talk to a lawyer. Are you signing your life away on your first contract, right? You set this company up, and we'll have some examples in here. And then legal help with a lawyer can help minimize the risk associated with creating a business. Contracts and compliance. This is we're in business, baby, right? We're doing it. We've set the business up. We are going to hire employees. Well, California, if you're watching this on video, I have a little funny cartoon here of a dumpster fire, and it says everything's fine. California is not only are we now the fourth largest economy in the world, just having surpassed Japan, but our labor law is a dumpster fire of disaster. And I'm telling you, if you are looking to do business in California or hire people in California, even a remote worker, if your business is in Ohio and you've got someone working remotely in California and they're a W-2 employee, you need to follow California law. So this is very, very important, certainly if you're operating a business in California. These, I would say, labor law is probably the biggest ticking time bomb potentially in a business. You have vendor contracts. If you're signing an agreement, somebody might ask for a 5-year commitment. You really need to read the fine print on that. Do you need a lawyer for that? I don't know. If it's big enough, you might. Maybe if it's a lease on a commercial lease and you're committing to $500,000 over 5 years, yeah, I would say I would want to have an attorney look at that. So but again, HR and labor laws are the big ones. California really is such a disaster when it comes to labor law that business attorneys typically say, I will handle all of your business matters, but the labor law is handled by a separate specialty. And there are a lot of firms out there that only do labor law, and those firms are typically divided into two kinds of firms that do labor law. One that does labor law for business owners, and the other one that does labor law for employees. So the business owner labor law attorney will be defending businesses. The labor law attorney that represents employees will be suing businesses, really. And so those are really separate practice areas. So again, a business, I would expect if you're seeking legal counsel And many times the business lawyer might not do the labor law, and the labor law attorney might not do the business law. So in California, it's subspecialties. So good legal compliance can save you, can help you avoid these nasty dumpster fires. So dispute. What if you get into a dispute with somebody? Do you need a lawyer? What if your co-founder goes rogue or your client's not paying you? Shocker, that never happens, right? Or there's a lawsuit over your name. That's intellectual property. We'll talk about that. This is where a legal advice can really help. And bigly, if you're watching this, it's actually is an adverb. It's a word. I looked it up. It was kind of a meme word, maybe 10 years ago or so. But a good attorney can help keep disputes from spiraling into financial sinkholes. But even better, a good lawyer can help you avoid a dispute in the first place. And again, if you're watching this on YouTube and not just listening to the audio, we have a quote here from Mark Twain, who said, "A good lawyer knows the law. A clever one takes the judge to lunch." So that is Mark Twain's wit. That is not how to win a case. That could be very unethical, but you get the point that legal counsel is very important. So exiting, winding up, and selling the business. When people say, "I'm out of here," if you're selling, you can sell your company, you can merge into another company, or you can close it down, right? So something's going to happen. Valuation, intellectual property transfers, employee terminations. That's another one. If you're closing a business, you still have to pay your employees who are separating, the PTO. You gotta pay them all that, the vacation, all those sort of employee benefits. You're still going to have to make that last payroll. If something is done wrong on the wind up or the sale or the exiting of a business, you can be personally on the hook. And a lot of people don't know that they're personally liable for many things, including labor law violations. So that's a very important one. There's some carve-outs in California. So Dylan creates CodeWisp, a software company, and sells it for $10 million. But because CodeWisp wasn't set up as a qualified small business under Internal Revenue Code Section 1202, Dylan pays $2.3 million in federal tax, when if it was set up as a qualified small business, he would have paid zero federal. Now, he still would have paid state in California, not in New York, but this is qualified small business stock. So this is an example. If you're setting up a company, be really mindful of, if you're setting this thing up to sell it, what does that look like? And you may want to engage, if this thing's really going to take off, you may want to engage a lawyer at the beginning, at the formation, with an eye on selling, not just, when you get that letter of intent, then reaching out to the lawyer. What about artificial intelligence? So obviously this has been in the news. It's everywhere. AI, I would say, is great for brainstorming, drafting, and explaining legal concepts in plain English. So what you can do is you can take a contract if somebody gives it to you and say, please summarize this for a fifth grader to understand, or an 11th grader. And AI is really good at summarizing what legal documents say, and really good at, if you have some terms you don't understand, define this term, tell me more. It really helps to learn. It is not, I would say, AI in our experience, and we use AI a lot. I mean, I use it every day, if not every hour. It is not great at judging risk or knowing nuanced state laws. So sometimes you have these nuances with states or even individual counties or cities where you really have to pay attention to the rules. AI isn't great at it yet. Who knows? Maybe one day it will be. Negotiating on your behalf, obviously, that's a tough one. And being liable for bad advice. There's, if you hire a lawyer and the lawyer gives you bad advice, that lawyer very well may have tort liability. Tort meaning wrong in French, but may have tort liability for doing the wrong thing that the lawyer did. But obviously with AI, you're not going to get that. But I would say think of AI as your smart intern, not your lawyer, to help out. There is also, for lawyers watching this, because we get a lot of lawyers watching these videos, lawyers are rapidly adopting AI, and it is changing the way lawyers work. And there's this thing called Jevons paradox from the 19th century in England, which described how improved fuel efficiency led to increased consumption. All right. Instead of saving fuel, efficiency improvements encourage wider use. So this had to do with coal and Britain running out of coal. When they had more efficient coal fired plants, the demand for coal actually increased. So I think the chief barrier to legal services, if you're watching this as a consumer or a lawyer, the number one impediment to people hiring a lawyer is cost. So if the value, if an attorney can deliver the same value for a less and less cost using AI, right? So instead of paying a lawyer $10,000 for an activity, you're going to pay a lawyer $1,000. You might have 100 times as many people looking for legal advice. So I think this Jevons paradox in the future is really going to affect how people engage business lawyers. Okay, so very, very important to think about, especially if you're a lawyer, because if you're not ahead of this and not quickly adopting, you may find yourself having a harder and harder time getting clients. How to reduce legal fees without shooting yourself in the foot. Great, great question. So if you're going to hire a lawyer, how do you spend the least money? Now, most people are concerned, hey, I don't want to waste money. I don't personally, I don't want to waste money. I don't like wasting money. What are some things that I can do? And our firm actually does hire attorneys for different things. Sometimes we need help in an area that we don't have expertise in. And I'm really mindful of that. I want to make sure that that lawyer's efficient, and I empower that lawyer to give me the maximum value with the least amount of time, because essentially legal services, broadly speaking, are fundamentally a fee for an amount of time involved. That's just on a very high level how it works. So I would say get your ducks in a row. If you're a client and you're looking at coming to our firm or some other firm and hiring a lawyer, I would say come in with questions, not chaos. Really think about what you're doing. Organize your documents, understand your goals, really think about your goals, verbalize them, put them on paper, speak them, however it is you verbalize your goals. But if you don't know what you want and you don't know the direction you want, you should expect to pay a little bit more, because there's going to be more counseling on the part of the lawyer. Now, you may reach this point where you go, Jim, I don't even understand how this stuff works at all. Then you need to be prepared to pay more legal fees. If you have already created 10 LLCs to hold apartment buildings and your lawyer retired and you need to create number 11, you're going to know a lot more, right, about what to do. And I think that'll really help reduce legal fees. Get a written fee agreement. How does a written fee agreement help reduce legal fees? Well, a written fee agreement is very important because competent business lawyers know to define the scope of representation. So one of the purposes of a legal fee agreement not only is to have it documented for, if you're going to take an income tax deduction for some of your formation costs, it's good to have a written fee agreement so you can prove essentially that you hired the lawyer. But having a written fee agreement really defines the scope of the services. So that avoids scope creep, as we call it for attorneys. So a client comes in, they say, I'd like some help with this particular matter. If you ask them to do something that's outside of that scope, expect another written fee agreement. But what that helps is that helps with keeping the legal fees down, to have a clear understanding between the lawyer and the client about what's expected. Don't wait for a fire. How do you keep legal fees down? An ounce of prevention is worth a pound of cure. So preventative law is cheaper than emergency law. It's cheaper to call your lawyer before you sign that lease than after your landlord sues you. Okay, so you want to know, what are you obligated to do under the terms of your lease? What can the landlord do to you? You want to have that all sorted out. And frankly, this is where AI really helps, because a lot of these leases could be 80, 100 pages long. You don't want to pay a lawyer to read 80 pages of a lease. I mean, you might, depending on the size of the transaction. But if you're signing kind of a normal size lease at maybe $500,000 in rent over a 5-year period, that's something where the lawyer should be using AI tools to help the lawyer go through it faster. Okay, it's not a substitute for legal advice, but it helps the lawyer get there faster. You can use AI for drafting and then get legal advice, so it's a great way to give the lawyer more detail, right? So you can use AI and then refine it. We won't judge you if you use AI and come to us to help you with this, even if you use, unless the grammar is tragic and there's a little smiley face if you're watching this on video. You can do a DIY to set up your business, and you can use AI, but none of those is going to replace a lawyer with a trained business lawyer who knows a terrain, spots landmines, and can speak to the IRS or judge if things go sideways. So that's really important. I think having that human element is very important. I would say use AI to empower yourself. Use a lawyer to protect yourself. So AI is about empowerment. AI is about learning. AI is about being better prepared when you go to the lawyer's office. That will reduce the workload that the lawyer is doing, which means your fees are going to be less. So, but you need that lawyer for protection. So keep watching, because at the end, we have the top 10 mistakes that business owners make, but it may be before the end. If you're watching this on YouTube, please subscribe to our YouTube channel. A little shameless plug. So I said this is going to be at the end, but I guess I didn't put the slides at the end. So top 10 mistakes business owners make without legal counsel. What are the top 10 mistakes that business owners make who don't have legal counsel. Well, let's take a look at these. Number one, choosing the wrong entity, corporation, partnership, or LLC. So when you go to set up a business, many people say, I want to set up a business. I want to have a corporate entity, and we'll talk about why it makes sense to do that. It does protect your liability. But do you use an LLC, corporation, or partnership? This is a whole universe of what you can and cannot use. We have a lot of webinars on our YouTube page on this. For example, if you're a professional, if you're a lawyer, you cannot have a professional LLC in California. You must use a corporation. So there's certain areas where you have to use a corporation and not an LLC. If you have a corporation, it will be taxed as an S corporation or a C corporation, right? And S corporation is typically a smaller business that doesn't pay tax at the corporate level. A C corp is like Apple or Nvidia. They pay tax at the corporate level, and those dividends, as a shareholder, you pay tax on those dividends. An LLC can be taxed as a disregarded entity, which means it does not file a separate federal income tax return, but it does file in California a state income tax return, and you report all that activity on your own 1040, your own personal income tax return. That would be an LLC taxed as a disregarded entity. Now, this is very confusing because LLCs can also be taxed as a partnership or as a corporation. An LLC can, let me say that again, an LLC can be taxed as a partnership, but not be a partnership. Or an LLC can be taxed as a corporation. That could be an S Corp or a C Corp. So it really depends on what's in the LLC. I would say if real estate is in an LLC, you're typically going to see that taxed as a partnership, potentially disregarded entity as well, but you'll typically see that taxed as a partnership. Why? It's because when a person dies owning a share in a partnership, that those underlying assets in the partnership get an adjusted cost basis at death, meaning that, if you bought something for 100,000 and now it goes up to $1 million and it's in a partnership, your heirs can sell that asset for $1 million and not pay capital gains tax. So very powerful. If it is a C Corp or an S Corp, you do not get an adjusted cost basis on the underlying asset. So it's very important. If you bought something for 100,000, it's gone up to $1 million, and that property is in an LLC taxed as an S Corp, or that real estate is in an S Corp, you're not going to get an adjusted cost basis on the asset in that corporation. There are some workarounds, but just understand that's the real reason why people are using partnership versus corporation when it comes to real estate. But choosing the wrong structure can mean higher taxes or, frankly, legal exposure. You want to get upfront advice on this, especially if it's real estate. And there are some defaults. So if you create an LLC and then you don't make your certain election, you're going to have a default under state law as to how it's taxed. So it's very important to pay attention to that. I would say on this one, you're going to want to get tax advice up front. This tax advice is going to come from typically your CPA and your business lawyer. TikTok doesn't count, by the way. It doesn't count as legal advice. Skipping the operating agreement with an LLC. So here, an LLC, an operating agreement basically is the terms and conditions of how this LLC runs. If it's you and you're a solo owner of an LLC, do you really need an operating agreement? I mean, the bank might need one if you open a bank account. But the problem is the real problem is if you have more than one person, or you have real estate that's going into an LLC. So separate issue there. But skipping the operating agreement, generally it's a bad idea. So if you say, hey, I'm doing this business with a friend, we're really good friends, we don't need a contract. Yeah, well, things may not always go so well, right? Someone's cousin might want to pay out. Somebody gets divorced, right? Do you really want to be partners with your partner's ex-spouse? I mean, a lot of people don't. So even friends need boundaries. Get it in writing. The operating agreement is a great thing not to miss. Mistake number 3 is not protecting intellectual property. I would say your logo, your brand, your name is very important, especially in the age of this age that we live in, the internet and AI. You really want to protect your intellectual property. So if your business has a name, you can trademark that. Okay, what does that trademark do? Well, that protects your name so that other people can't steal your name. So if you're investing a lot online with online marketing, trust me, you're going to want to protect that. We've protected Cunningham Legal, like the name Cunningham Legal. That's a registered trademark. So that is very, very important that intellectual property is protected. So this goes to names, taglines, whatever it is. And that's something that lawyers help with those type of things. Using Frankenstein contracts, piecing together contracts from the interweb does not end well, right? You want to have a lawyer make sure those are you got a lawyer behind those. Now, a lawyer may be able to help you write that contract. Also, there are trade associations you can get contracts from. Realtors use California Association of Realtors. But whether you're using attorney drafted, trade association, whatever it is, make sure you're using the updated version, even if it costs you $700 a year or it costs you a couple $1,000 with the lawyer, whatever it is. You're going to want to make sure and use those updated forms because the law does change, and you're held to those standards, even if you're not aware of the change in the law. So I would say Frankensteining together contracts can be scary, like Frankenstein was scary when I was a little kid and saw it. Ignoring employment laws, misclassifying employees, ignoring overtime, not paying people appropriately. Here's a little insider tip. We give every employee a personal device allowance on every paycheck. We pay them a small-ish, I mean, it's not tiny, but we pay each employee every paycheck a certain amount of money because there was a company in California that got sued because they had their employees using employees' cell phones and laptops to do work, but weren't paying them. That's an example of sort of the craziness of California law. Stay compliant, spend the money, have your employee manual updated annually, pay attention to HR, pay attention to labor laws, because in California, if a litigant, if a former employee successfully sues you and gets $1 in damage, you have to pay that former employee's or current employee's legal fees. So that's the biggie. EPLI employees liability protection policy is one you can use, which is insurance against employment lawsuits, but typically it just covers, it doesn't cover the damages. It really covers just the legal fees typically. So no terms, conditions, or privacy policy. So this is actually really important to understand. If you don't have rules on your website, you're vulnerable. So websites have to be ADA compliant. And I don't want to get too heavy in the tech, but if you're running a business, you're going to have an online presence. You will be collecting user data. You will be collecting consumer data. This is names, addresses, emails, cookies, IP addresses. This requires a privacy policy, especially if you're dealing with residents of California. California is the CCPA and the CPRA, as well as the EU, which is European countries, GDPR, and that's really the heavy one and the heavyweight. Other states and countries have data laws, and if you have a website, if you have an online presence, you're going to be subject to those rules. Skipping this privacy policy can lead to really serious big daily fines and legal headaches. You want to have good terms and conditions and privacy policy and get your digital legal affairs in order. Signing a lease without a review, I would say this is a big mistake. A standard lease usually favors the landlord. A legal review can help reduce these poison causes and hidden costs. So the gotchas in there, one is like holdover. They might charge you 200% or 300% rent if you stay on the lease beyond the term. So there are a lot of gotchas in there. And, certainly we're in a very soft, in most markets, a very soft office space environment. And you really can get some leverage on landlords, at least in 2025. Waiting until you're sued to get a lawyer, bad idea. So once you've been served with the lawsuit, you should have been talking to the lawyer before that. Preventative law is cheaper than emergency law. So a lot of things that people get sued on are preventable. Okay. These are things where you go, I really have to do this under, and a lot of these are labor law, quite frankly. Do I really have to do this under California labor law? The answer is there are many things that consenting adults can do in California, and the list is very long, but working through lunch is not one of them. Not taking your two 15-minute breaks or 10-minute breaks during the day is not one of them. So you have to be very mindful of California labor law because that is a big gotcha. No exit strategy on a business. So there will come a day when you will no longer be involved in your business. Either you will close the business, you will sell it, you'll give it away, you'll die, right? Someone else will have to do that. If you have no plan for exiting your business, there is going to be more chaos than if you don't have a plan. I would say plan your exit like your launch, but with legal help. So this is something that you can build into the business in the operating agreement on the LLC, you should address what happens if people get divorced, if people go into bankruptcy. You don't want to be partners with your partner's bankruptcy creditors. So there are a long list of things where you'd want to address those. That's just sort of basic business hygiene. Not budgeting for legal fees is number 10, right? We'll just deal with legal later. That's a really bad strategy. Budgeting for legal in your business plan does make sense. It's part of doing business, and frankly, it's not that much money. I mean, I know lawyers are expensive, but setting up a business when we look back and we kind of look at the P&L on what a business has done, many times the legal fees. There are significant savings opportunities if you invest that money in legal rather than waiting for problems to come up. So bonus tip, legal doesn't have to be astronomically expensive, just intentional. I would say preventative advice beats emergency advice every time. Well, what is a real human business lawyer? So what is that? What is a business lawyer? A business lawyer is a legal professional who helps informing, operating, and protecting businesses and business owners. They provide, now this is not so much for the employees, right? Now you may be an employee of your business, but this is really the business lawyer is the lawyer for the company, right? For the corporation, for the LLC, for the partnership. And that business lawyer provides legal advice, drafts and reviews contracts, and assists with compliance regulation. Business lawyers often focus on areas such as entity formation, contract negotiation, mergers and acquisitions, intellectual property, and tax planning. Sometimes you'll have an M&A lawyer, a mergers and acquisitions lawyer. That's kind of what they do primarily. Other people may be primarily focused on setting up businesses. Other people may be focused on litigating businesses. But broadly speaking, this is what business lawyers are doing. Labor law attorneys, and this is California. This is kind of unique to California in my talking with other lawyers across the country. Labor law tends to be a specialty carve out. So it is not uncommon for a business to engage a business lawyer and a labor law attorney, oftentimes not the same lawyer. Now, these could be two lawyers within a firm or two separate firms. And sometimes it's good to have your labor lawyer separate from your business lawyer. That way, it just depends, but there is a benefit in having just a standalone labor law attorney in there. So beyond legal counsel, a business attorney does more than just provide legal advice. We're a part of your team, right? It's almost like a board member. We help develop proactive strategies and here to help you address unique challenges that your business can face. And our goal is to help your company create lasting impact and thrive for multiple generations. At Cunningham Legal, we handle the compliance, contracts, and negotiations so you can focus on growth and innovation. Now, obviously, you're involved in the contract negotiation, but you do need a lawyer to make sure that what you want is accurately reflected in all that legalese that's in the contract. When do you need a business lawyer? When you're starting a new business, I would say that's when you need to consult with a lawyer. Can you go online and create an LLC? Yes. Can you go online and create an operating agreement? Maybe. But really, if you don't know what you're doing, this is too important. Just hire the lawyer. Frankly, it's not that much money. And at some point, you just need to get over it, hire the lawyer, get it done. If you're creating a corporation, LLC, or partnership, there's a lot of paperwork. There's a lot that can go wrong. And I will tell you, one of the most common problems or mistakes is people do not make the correct tax election. And then sometimes you cannot pull the cream out of the coffee, right? You can't undo what's been done. So you really need to pay attention to that. Not only setting up the entity, but also the tax status. Very, very important. Have you filed your annual filing? If you set up an LLC or corporation or partnership, there is a requirement with a corporation, an annual filing every 2 years. With an LLC, you need to update your records with, at least in California, the California Secretary of State's office. When attempting to secure patents, trademarks, or copyrights, again, there are specialty lawyers, many of them that do this. It's very important to do that. When we did it with our firm, we actually hired another firm to do that. It just wasn't that much money, right? Wasn't a big deal. Hire the lawyer before the purchase, sale, or merger of a business. It's best to hire the lawyer before you agree to that LOI, that letter of intent, or that term sheet, right? Before you agree on terms, it's better to talk to a lawyer. And if you're trying to pay less in business taxes, it's good to talk to a lawyer before the filing deadline is just around the corner, right? So if we're in 2025 right now, if you want to pay less income tax in 2025, it's really good to engage the attorney probably in the second or third quarter of 2025 to help you with that. Why do you need a business lawyer? Why on earth would you need a business lawyer? Well, you need a business lawyer to select your entity, LLC, partnership, or corporation, legal compliance, all that stuff you have to do to maintain your business, liability management. We're going to talk quite a bit about that. Business transactions and disputes. If you're setting up contracts, signing contracts, dealing with vendors, protecting your intellectual property, very, very important. I think this has become much more important than it used to be with the internet and all the technology that's out there. Very important to protect because anyone can rip you off at any moment. So all that money you put in to build your brand, if you don't protect that, someone can just rip it off and duplicate it, and really you have very less recourse than you would if you had protected it. And financial planning and tax matters, and then growing the business and succession. So those are all things where a business lawyer can really add value to a business. Let's talk about entity selection and formation. So if you're creating a business, should it be a partnership, corporation, or LLC? A partnership is like dancing the tango, as they say. It takes two to tango. If you have a partnership, two people. Could you have a partnership of LLCs? Yes. Could you be in partners with your living trust? Potentially. So a partnership, we use the term person loosely, but typically it's going to be two people or two tax-paying entities. Corporation is a separate legal entity. You can have a single shareholder. You can have millions of shareholders, right? Like a publicly traded company. It issues shares. It has bylaws. It has a requirement of an annual meeting. There's a board of directors that elects officers, and the officers serve at the pleasure of the board, and the board represents the shareholders. If that sounds horribly complicated, right? The LLC is kind of the opposite extreme. The LLC is a limited liability company. That can be 1 people. It could be 100 people. There is no requirement for an annual meeting. There's no board of directors. They're members of an LLC. You have managers of the LLC, but it's really, I mean, you can have a board of directors in an LLC, but you're not required to. With a corporation, you are required to. So different flavors. I would say partnership is the oldest one, Cain and Abel, going way back, partnership. Corporation, 1600s, started out in Holland. LLC, 1977 in Wyoming. That was the first LLC. Corporations can be taxed in 2 ways. This is very important. A C corporation is effectively the default. And so what that means is you are taxed as a C corporation if you do not if you set up a corporation and you do not elect to be taxed as an S corporation, you are taxed as a C corporation. What does that mean? Well, that means the C corporation pays taxes on its profits, and then when you turn around and take those dividends, you're taxed again on the dividends. Okay, so an S corp was created 50 years ago, more than 50 years ago, to say, that's kind of a ripoff. Can't we just have a subchapter S corporation? So this is a provision in the Internal Revenue Code where the corporation itself doesn't pay tax, but only the shareholders pay tax at their own shareholder level. So there are different reasons why you would use a C corp versus an S corp. We did mention earlier in the webinar or in the video, qualified small business stock. That's Internal Revenue Code Section 1202 stock. That allows you to exempt capital gain on up to $10 million or 10 times your cost basis. So you don't pay federal capital gains tax on that. Pretty good deal. So that would be a reason to have a C corp where you might not, where if you have an S corp, you don't have that benefit. Most people, though, I will say for smaller operating companies, most people go with the S corp route. So that's what we see for smaller companies. Business compliance. So what is business compliance? Well, you have your articles of organization. If you're going to set up an LLC, this is the formal paperwork required at the state level to set up your LLC. Statement of information must be filed in California, must be filed within 90 days of registering the LLC with the Secretary of State. After the initial filing, they're required to submit this document every 2 years. The statement of information says who are the managers, what's their address, who's the agent for service of process. So if somebody sues the LLC, if you create the LLC, your name is on the articles of organization. If you're the manager of the LLC, your name is a matter of public record. Some people say, I don't want my name on any public filing. So if you hire our firm or another law firm, well, certainly if you hire our firm, we're the organizer. So your name won't appear there. On the statement of information, you can use a New Mexico LLC as the manager so that an LLC appears as the manager. So a little bit more level of complexity, but the bottom line is you can keep it private. It's just a slightly heavier lift, and that's something that we help clients with. So if you're into privacy, we're a good firm to use because we can keep your name. So if you're a public figure and you don't want to be out there, or you're a famous person, whatever it is, then there are ways to keep your name off that. Operating agreement is not a public record. There's no, there's no reporting requirement if you have an operating agreement or not, with one exception, I will say, on real estate. But an operating agreement defines the roles and responsibilities of the members and managers, outlines the decision-making processes, and sets the rules for profit sharing among members. If you have real estate, and you create an LLC and you put real estate into the LLC, which is very common for our clients to do, the assessor, the local county assessor, will want the schedule of members. So if I have a piece of property and I put it into an LLC and I own 100% of those shares, the property is not reassessed when it goes into the LLC, but the assessor is going to ask for the schedule of members. They're not going to ask for the operating agreement. They just want to know who the members are of that LLC, so that they know whether to reassess the property or not. So that's a little bit of an insider tip, if you will, on dealing with real property in California and putting that property into an LLC. So very, very important. Business licenses and permits. If you're doing business, you've got to check with your local, wherever you're doing business, you have to check with your local regulations, because cities, counties have their own regulations. And then you've got your tax documents you're going to have to deal with, your tax compliance, typically with the CPA. In California, partnerships, the partnership agreement explains the management roles of each partner, detailing how responsibilities and decision-making is made. If it is a general partnership, there is no requirement to register it with California, but you can. It's optional. You can register it with California. If it's a limited partnership, you must register it. Fictitious business name statement is a required filing when a business operates under a name different than the owner's or partner's legal name. So that's very important. So if you're not operating under your legal name, then you have to register that. So if you have a partnership that is not registered with the state of California, you would have to get a fictitious business name statement in the county that you're primarily, that you're headquartered in. So that's a rule on that. And again, business licenses and permits. If you're a partnership, you're going to be subject to all the local requirements. Again, this is a reason to get a business lawyer, because if you say, gee, I'd like to do a partnership in the city of Los Angeles, you're going to be paying some taxes to the city of Los Angeles. You're going to be paying some fees. You're going to be paying a license tax. If you're a law firm in the city of Los Angeles, you have to pay a 0.5% gross receipts tax. So if your firm grosses $1 million a year, what is that, $5,000 a year, you would have to pay, even if you don't make any money, right? So that's what attorneys have to pay. Boo-hoo, attorneys have to pay that to the city of Los Angeles. Partnerships have to file a Form 1065. That's the U.S. partnership return. Each partner gets a K-1, which is the income that's reported to the K-1. So the partnership has to file a return but doesn't pay tax, and then the partners get the K-1 and the partners pay the tax on the K-1. And the California has a Form 565 that you file with the California Franchise Tax Board. So 2 filings that you've got to do, state and federal. Annual reports. So for a California partnership, some may be required to file annual periodic reports. Limited liability partnership is typically reserved primarily for lawyers. They're required to file an annual statement of information with the Secretary of State. We do have a link here on the reporting requirements for all of these, and we've got that in the notes there. So if you're like, oh, gee, I did an LLC 5 years ago and I haven't done anything on that, yeah, you probably need to check that out and make sure you're compliant. Asset protection is a part of proper business planning. So let me say that again. Asset protection is a part of proper business planning. So we'll use an example. Rancho Fuego. Oscar owns Rancho Fuego LLC, which in turn has title to the real property that is known as Rancho Fuego. Now, Rancho Fuego is Spanish for fire, for those of you who don't know what that word means. Romeo, the ranch hand's clearing brush and using a controlled burn. The controlled burn gets out of hand and jumps to an adjacent ranch, burning structures and causing other damage. The neighbor successfully sues. This is very important. The neighbor takes the assets of Rancho Fuego LLC, but not Oscar's other assets. So Oscar's the owner of Rancho Fuego. There's a fire in Rancho Fuego that spreads to the other owner. That is the fault of an employee of Rancho Fuego LLC. So this is an example of inside liability, and we'll talk about that in a little bit. Inside liability, the assets of the LLC are available to satisfy the claims of the judgment creditor, who was the neighbor, but not Oscar's personal assets. If this ranch was in Oscar's name alone, the full personal assets, all his personal assets, would potentially be available to the creditor. So very important. Let's look at an example of a corporation. Alpha and Bravo create Yummy Ube Inc. Ube is a Filipino sweet potato that is made into ice cream. And I had this for the first time a couple of years ago. It's really good. So Alpha and Bravo, they create Yummy Ube Inc. And Echo is an employee of Yummy Ube Inc. Echo Echo is rear-ended by a drunk driver, right? So Echo's pushed into a van carrying 10 physicians, all of whom become paralyzed, and there's $100 million in medical bills. Under California law, Echo, the employee of Yummy Ube Inc., even though he's only 1% at fault, is jointly and severally liable for what we call special damages. So this is the medical bills, the $100 million medical bills. So the drunk driver who hit Echo and pushed Echo into the van of lawyers, even though it's only 1% liability, the full $100 million can be recovered against Echo or Ube Inc. But again, the recovery is limited to the assets of Yummy Ube Inc., not Alpha and Bravo themselves. So those two partners, their individual assets are not subject to creditor's claim. That is outside liability. That is not, that's an example of inside liability, actually. Outside liability is best described as personal liability. Inside liability is best described as business liability. So outside liability would be, in this case, Alpha and Bravo. Maybe Alpha gets into a car accident and causes damage. Can the creditor take his shares of Yummy Ube? Maybe, maybe not. We'll talk about that in a little bit. But this is what we're talking about here. These are two instances of inside liability. And the idea is, if it's inside liability, you want to contain it to the assets of the entity, not have that go out and be able to go against the personal assets of the owner. So very, very important. You don't want that if you're a business owner. So what is asset protection? Asset protection is a component of financial planning. It is designed to protect assets from creditor claims. Individuals and business entities use asset protection techniques to limit creditor access to certain valuable assets while operating within the bounds of debtor-creditor law. So very important, this whole area of debtor-creditor law. But the idea is, if you're engaged in business, you want to protect your investment, you want to protect your personal assets, you want to limit liability to the activities of the company. And, this is not about not paying your bills. This is not about not, adequately having people compensated who are injured, but this is about limiting the recovery, right, to certain buckets of money. So the idea is, instead of having everything in one big bucket where it can all be taken, you're breaking it up into smaller buckets, maybe a partnership bucket, an LLC bucket, and a corporation bucket, and maybe a trust bucket or something, right? So the idea is you want to separate it out. What is not asset protection? It is not doing something after you are sued. Almost every single call we get from a client who says, Jim, I'd like to do asset protection, there is something going on. So this is, a lot of times people are worried about a lawsuit. They're in the middle of a lawsuit. A lot of people are coming out of a lawsuit where they just wrote a check and they're like, I don't want to stress like that anymore, because this is about being able to sleep at night, okay? Because people are worried. The reason people seek asset protection is they don't want to lose what they have. And a lot of people worry about losing what they have once they get it. So it's very, very important. Asset protection needs to be done before the liability arises. It is not insurance. So insurance is designed to pay off a creditor so they don't otherwise take your assets. That asset protection is not insurance. Insurance has really there's three components to it. Time. Insurance covers you for a stated period of time, typically 1 year, right? Policy limits. There's a maximum that insurance will pay $1 million. If the recovery is 2 million, the insurance is only paying 1 million. And then you have the constraint of coverage. If it's an auto policy, they're not going to cover you for a fire on your ranch, right? They're going to, well, it's an auto policy. So very, very important. And a living trust provides zero asset protection for the creator of the living trust. So the person who set it up, remember, zero. I do want to talk about charging order protection. It's good for the debtor. So if you are seeking to protect your assets, a charging order is a court-ordered lien placed on a member's interest in a business. So what we have here is we have Oscar, the owner, and something happened, and Oscar is now liable. And so an example here is maybe the neighbor's house burned down or something, and so the neighbor's suing Oscar and wants to recover Oscar's shares of the LLC to satisfy the judgment. A charging order protection, which California does not offer for California LLCs. You have to go out of state, and Wyoming is where most lawyers go, the Wyoming Close LLC. The benefit is if you own those shares of the Wyoming Close LLC, your creditor can only get distributions that would otherwise be paid to you. It does not grant the creditor any ownership rights or the ability to become a member in the LLC. So this is very nuanced. So you are getting sued, or you've been sued, and you have a creditor who's seeking $1 million against you, and you have shares of a Wyoming Close LLC. If any money is distributed, that creditor gets it. If money is not distributed, and many times these are taxed as S corps, or they are taxed more likely a partnership, the LLC does not distribute money, but that creditor can get a K1, right? So they're taxed as if they own the money, as if they get it, and that's problematic for the creditor, because they're getting this charging order, they're getting this K1, but they're not getting the money. Okay, so a creditor can't foreclose on the membership interest and interfere with the LLC's operation or force the company to make distributions. In California, a creditor can foreclose against your LLC units, can become a member of the LLC. So California has very little creditor protection. That's why people go to Wyoming. If the close LLC chooses not to distribute the profits, the creditor receives nothing, potentially leaving them with taxable income they never actually received. This is called phantom income. This protective structure makes Wyoming Close LLCs attractive for asset protection and estate planning purposes. These are widely used in California. Maybe counterintuitive. How can a Wyoming Close LLC, by the way, a Wyoming Close LLC is just a Wyoming LLC with a special operating agreement. So the secret sauce, the magic is in the operating agreement. It's a close LLC, and it limits the rights of third-party creditors. So this is can be a fantastic tool, and is used in combination with other tools as well. So again, California offers little outside creditor protection. California allows creditors to foreclose on a debtor's membership interest in an LLC through the use of court judgments. This really stinks for single-member LLCs that have no other partners to prevent the complete liquidation of the company, and for multi-member LLCs who don't want to distribute assets out of the LLC. So Alpha and Bravo put their $1 million portfolio into a California LLC. The creditor can foreclose on Alpha and Bravo's membership interest and get the $1 million. This does not happen with a Wyoming Close LLC. Okay, you have that charging order protection. So when you're weighing LLCs and, do I need to hire a lawyer? You may want to choose Wyoming LLC over California. Now, sometimes we put the two together, and this may get a little too in the weeds. And if you're listening to this and not watching the what we have on the screen, I would encourage you to go back to YouTube and when you're not driving or walking, and look at this slide, because this is a holding company structure. So a lot of lawyers, a lot of practitioners will set up a Wyoming holding company that's an LLC, and what the Wyoming holding company owns are a bunch of other LLCs. So you might put your California real estate into a California LLC, and then put the shares of that California real estate into a Wyoming holding company. Now, why would you do that? Well, because you don't have the same protection if the Wyoming LLC owns the California dirt directly in the Wyoming LLC. You need that separation. So most of the smart kids, most of the experienced lawyers are setting up a holding company structure for a lot of different reasons, but I did want to go over the concept of a holding company. So the holding company owns shares of a California LLC. Alpha and Bravo and Greenacre, a 25-unit apartment complex. The dirt, bricks, and sticks of the apartment complex are owned by a California LLC, and the shares of the California LLC are then in turn owned by the Wyoming Close LLC. Alpha and Bravo's Living Trust owns the shares of the Wyoming Close LLC. Alpha and Bravo now have charging order protection from outside creditors to protect their equity in Greenacre via the Wyoming Close LLC. So if you didn't get that, you can rewind that, listen to that again. This is a multi-step process, but this is what the more sophisticated client plans, and there are a lot of other reasons to have a holding company for like dynasty trust purposes and other purposes that we cover in other webinars, but I did want to cover the concept of a holding company. So if you have capital assets, typically it's going to be real estate. This could be done with operating businesses, but we see it a lot of times with real estate. So why use a business lawyer for contracts? Can't you just use AI, right? Because lawyers are experts in drafting contract terms. Sophia launches her Dream Cafe. She drafts her own lease agreement with the landlord. The lease includes a clause for early termination without cause. She just pulls something off the internet, doesn't really read it. After investing a lot in renovations and marketing, Sophia is shocked when the landlord invokes the clause to take the lease space back to put a higher paying tenant in there. So Sophia lost all of the improvements she put into the property. Or Ethan, a new landlord, uses a generic lease template he found online, and his tenant begins defaulting on rent payments. When Ethan tries to enforce the lease terms, he discovers the agreement lacked clear clauses about late fees and eviction procedures. So stuff that you pull down online, it's kind of a crapshoot. You don't know what you're going to get. That's why it's good to engage a lawyer, because if the lawyer screws up, you can sue the lawyer for malpractice. I mean, that's the bottom line, right? And they're going to know what they're going to do. So hopefully you would avoid that. Business lawyers are experts in reviewing contract terms. Too often people sign contracts without reading them. Yeah, that never happens, right? If a contract is not favorable for you, an experienced business attorney will be able to suggest revisions and often negotiate on your behalf. So Emma is excited to collaborate with a well-known designer for her boutique fashion line. Anxious to secure the deal, she hastily signs the agreement without legal review. After a disagreement with the designer, she was blindsided when she discovered that the contract entitled the designer, the person she worked for, exclusive rights to the designs that Emma did herself. So there's a gotcha in there, right? So you really need to pay attention to the fine print. And lawyers help with managing contract breaches and disputes. So a lot of times you'll have a problem. You'll come to the business. And by the way, there's a business lawyer and business attorney. I'm not using these interchangeable. A lawyer is a human that dispenses legal advice. So when you go to the lawyer's office to set up your operating agreement, they're giving you legal advice. They're your lawyer. When a lawyer goes to court, they're an attorney, so they're acting on someone else's behalf. So that's why I'm using the term lawyer and attorney. Maybe I'm splitting hairs on that one, but an attorney can draft and send formal demand letters to a breaching party. Meaning, if somebody is not paying you, or someone's doing you wrong, or they're not upholding their end of the bargain, that attorney can look at the situation and then act on your behalf. So they can send a letter on your behalf to making a demand, or pursuing an action in court, or defending you. And then they can draft the settlement agreement. And this would be like a vendor fails to meet a deadline, employees not performing at the level they've agreed to. You would be involving your labor law attorney potentially. You might be terminating that employee, as well as lease violations and issues. Briefly, intellectual property is very important. Again, trademarks, patents, copyrights, you need to protect your intellectual property. The patent process requires public disclosure of how the invention works. So lots of companies opt for trade secrets. So what's the difference between a patent and a trade secret? Well, Coca-Cola has protected its formula as a trade secret for over a century, because if they had patented it, the formula would have become public knowledge after a period of time. The same is true with WD-40. That's under trade secret since the 1950s. The company decided against patenting it to keep it from disclosure. So the precise ingredients aren't well known, but WD-40, there's stuff better than I have WD-40 and the Teflon stuff as well. So different applications, different products for different applications. How do you protect intellectual property? So how do you keep trade secrets, patents, or copyrights? Use non-disclosure agreements with employees, contractors, and other parties. Again, you're getting into labor law when you have employees. Have strong security measures. Have strict access limits on who can view or modify sensitive data, and be prepared to enforce your intellectual property rights through legal action if necessary. But you have to perfect those intellectual property rights. So really focusing on your name, your branding, All of that because, again, you may invest significant amount of money and then somebody can just rip you off online. And, it's going to be a lot harder for you if you haven't perfected those interests. What about beyond legal counsel? An attorney does more than just provide legal advice. We're part of the team. We help develop proactive strategies and we're here to help address unique challenges that come up in the business. It might be a sounding board, right? A board member, whatever it is. Our goal is to help your company create a lasting impact and thrive for multiple generations or not. You may be building something that just, you say, we're building this and in 5 years we're selling it and we're going to do qualified small business stock, that section 1202 stock, because I watched Jim's video. We're going to do a C Corp and we're going to be able to walk away with a $10 million capital gain and not pay tax and save $2.3 million. It's a pretty good deal. In our firm, we handle the compliance contracts and negotiations so you can focus on growth and innovation. Again, also this involves estate planning. So if you're a business owner, you have a business, you really need to have your estate plan and your business integrated in a sense, or your estate plan should be addressing your business. Your business should be addressing your estate plan and your operating agreement, your buy-sell agreements, whatever it might be. And we're here as a firm. We're here to help you with your successors to build their skill set and continue on. Business succession planning is crucial for the seamless transition of your company from one generation to the next. So if you're in that place of you're in business and you say, I'm really thinking about the next generation, that's really where we shine at Cunningham Legal, and we can help you out with that if you're not already represented by an attorney. So what is business succession planning? We talked a little bit about that. It's a preparation for an eventual change in ownership. So if you're a human watching this, and I'm sure AI's already scanned it, but if you're a human watching this, we all leave this earth, right? We're here for a period of time and then we're not. People retire. People have to stop working. People sell their companies. That is what we're talking about succession planning. So you're in the business and one day you're not going to be in this role. You might not even be in the business, but really it's a creation of a process for the future transfer of leadership, ownership, and management of the business. This is retirement, incapacitation, or death, or loss of key personnel. That's another one. So if you're running a business and you have key people, you need to think about if those people go, what's the plan for those key people if they leave? What's the plan for the business? We're talking about the peaceful transfer and continuity of the business, minimizing potential disruption. And this planning helps avoid uncertainty. It helps preserve business value. If you have a really good business succession plan in place, that can be very meaningful to preserve the value of the business when you stop participating in the business and it's time for you to extract value or money from the business. Having a good succession plan increases the probability that you will be getting anything from the business, if not more. So very, very important on succession planning. There are 4 paths. I did not come up with this. This is Patrick Ungashik. He came up with these. These are the nicknames he gave them. There is the passer, the innie, the outie, and the squeezer. The passer is when you transfer essentially like a family-owned business to a family member. So you're passing this business on one generation to the next. The innie is transferring the business to a key employee. So it looks a little bit like the passer, but the inside transaction goes to a key employee, typically for money. So the passer is somebody who says, Johnny, you've been working in the business. You're my son. I'm going to give this business to you. That does require some estate planning because if you got other kids, that could, you're going to have to deal with that. The innie is the inside transaction, typically to a key employer, key employees. The outie is a transfer to a third party. So this is an outside sale. This is where you get your golden parachute, you get your big chunk of change, and you go off to the beach and have your refreshing drink under palapa or something. Then there's the squeezer. The squeezer is somebody who's not passing the business to anyone. The key employee's not taking it over, and there's no outside buyer. A lot of businesses, it ends up, they just squeeze all the value they can, and then it closes, it ends. A lot of solo practitioners are like this, solo practitioner law attorneys. So if you're an attorney watching this, you're like, ooh, that sounds like me. A lot of these lawyers, they just work and they kind of wind their practice down and they close their doors. So there's nothing wrong with that being a squeezer. We're just giving it a name. So business succession planning can be really difficult for a lot of people, to put it mildly. We're here for you in the next generation when the time comes to transition your business. We can make sure there are detailed instructions for the next generation with proper business succession planning. By the way, if you're a business owner, you should document all of your processes, all of them. So it doesn't matter if you're a 2-person shop or a 10,000 person shop, right? You should be documenting, have everything written down and documented, because you may have a key employee who walks out the door with all those processes in their head. And, if it's not documented, it reduces the value of the business, quite frankly. So unlike a solo lawyer, Cunningham Legal, our firm, we offer the stability of a full service firm when it comes to estate planning and business. So we're here for you and your business over the long haul, rather than being a one-off attorney. Because this is some of the feedback we get from clients. They say, well, I've got this great attorney, but he said he's going to be retiring in a couple of years. So we're looking for a law firm we can go to, so that if we go to another attorney, that attorney won't be retiring, and we're just going to have to keep popping from solo practitioner to solo practitioner. So it's something to bear in mind as a business owner. There's nothing wrong with hiring a solo practitioner. Just bear in mind that if that person is a squeezer and kind of squeezes out the value of their practice and closes shop, you're going to have to find another lawyer. This brings us to the end of our time today. We do have offices in Northern and Southern California. We also meet virtually on Zoom, but pretty much all the meetings I have with clients are on Zoom. Very few are in person. Next up, May 1st, May Day, we have Prop 19 loopholes, how to keep your low Prop 13 taxes. This is going to be a good one. If you own real estate and you want it to go stay in the family and not get reassessed, or not get reassessed as much, very, very informative webinar. We're going to cover a lot. Share this with your friends and family, but this is going to be a biggie. So this is a very popular one, and we have some new material, some new ideas. So always kind of a moving target. If you're watching this on YouTube, please subscribe to our YouTube channel, and we will open it up for questions. If you're watching this on YouTube, keep watching YouTube, because the next video magically is going to roll right after this one. Thanks for joining us.